Why do I have the feeling I'm not being told the truth? I've got two tests back to back with cocaine. So let me ask this question. I send you over today and I get those results immediately. Is anything going to show up in your system?
The coaches, Your Honor. Miss Kingsley, can you please state your name for the record?
Brianna Kingsley.
Well,
Your Honor, I have submitted an adjournment form to the court. We have some continued negotiations. I did send a mitigation report for review by the prosecution. They're asking for her next pretrial is set for February 25th, 12th. I understand that the court can't go out that far. I do.
well, that's in 15th.
Correct.
But as I'm reading this, you're trying to track that case.
We are trying to track the cases together too, just to see what's going on in terms of mental health treatment, Your Honor.
Okay. Back up a second.
Sure.
Haven't seen Miss Kingsley for a while. Is she in mental health court there?
She is not. She is getting mental health treatment, however, outside of the court.
Got it. And so that's, correct me if I'm wrong, that's being monitored kind of with the 15th District Court case.
That is my understanding.
And you're trying to follow along with some of that information regarding this case.
That's correct, Your Honor.
So why wouldn't I put it out after?
I would be asking for you to. I just didn't know if the court would be willing to do that for me.
You know, Bellinger, sometimes you just have to ask, but you always just ask for the wrong stuff.
Oh,
All right, this one I would do. This is not a problem. All right, so
Then we're asking.
okay.
what?
Then we're asking.
She got
Well,
this.
I know. Mr. Kingsley would ask me. I just don't know why you did.
I was trying. I was going to get there.
Well, quit taking the scenic route. So your next date in 15th is the 12th?
Yes, sir.
All right. So let's go then, so you can figure that out. I won't go to the next date. Let's go to February 20th, given all circumstances.
Thank you, Your Honor.
February 20th, 2025, 9 a.m.
Okay. Here you go.
I'll do that for Miss Kingsley.
Thank you.
Right?
Thank you.
Yes. Happy New Year. Court calls the case, People versus Eric Mayfield.
Your Honor, Alexis Plumai, Assistant Public Defender, appearing with and on behalf of Mr. Mayfield. Mr. Mayfield, could you say your full name? Your Honor, we are asking for an adjournment here. I would just ask for 2 weeks.
Without objection, January 16, 2025, 9 a.m. bond continue.
Thank you, Your Honor.
No, Court calls the case of the People versus Antoine Patterson.
Assistant Public Defender J. Vaughn, John B. Mr. Patterson, Antoine Patterson. Your Honor, I have done everything to try to get a hold of my client, less a carrier pigeon. I have not been able to do so, unfortunately. I have reached out to prosecution in order to try and get an offer on this case. Still haven't heard from my client. That being said, I would ask for an adjournment. Am I asking for the wrong thing again?
We would object to that.
No, you're asking for the right thing. Just deny. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000. Cashier.
Can we make it 10?
You want me to add 10?
No,
Okay.
less 15.
That warrant will enter me. Thank you.
Thank you. Have a good day.
Are you done?
I am.
Bye.
Welcome.
Wait till he leaves the room. Court does call the case People versus Levante Washington.
Public Defender Natalie Pate with and on behalf of Washington, who is approaching the podium. Please state your name for the record, sir.
Levante Washington. Thank you, sir.
Thank you, Your Honor. As to the probable cause conference, we are respectfully requesting a very brief adjournment. And we do understand that Mr. Washington was asked to be in person today because of the progress report that was sent out. And we are also willing to address that when whoever the court would like.
Why don't you go ahead and address that?
So as the court is aware, Community Corrections did send out a progress report. Mr. Washington did test positive on both 12/27 and 12/30 for cocaine. He did already send out the 12/27 sample to the lab for confirmation. We have not yet received the results from the lab one way or another. He does plan on, after court today, appearing in Community Corrections to have his most recent test sent out for confirmation from the lab. He had planned on doing that today in any event. However, as to the progress report, we're asking the court to hold it in abeyance until we get those lab confirmations back, whether or not that was a positive test. Mr. Washington does deny any use. He is here today with his mother, who I have also had the opportunity to speak with. He resides with his mother, and his mother also says she doesn't know him using. Of course, she's not with him all the time. However, Mr. Washington does deny use. That's why he sent it out to the lab. So we're just asking the court to hold this in abeyance until we get that confirmation one way or another.
And then if it comes back positive, what do you think I should do?
I would ask that be addressed at that time.
So you just don't want me to lock him up today?
Certainly not today, Your Honor. Mr. Washington appeared knowing that that was quite frankly a possibility. He's staying on top of this, continued to test even after he did get that positive result, went to Community Corrections and paid the $30 to have that sent out.
You going to have a test today?
Yes, he's appearing. He is going to go to Community Corrections after court today to have his test from the 30th sent out, and I believe also to be tested again.
Why do I have the feeling I'm not being told the truth? I've got 2 tests back to back with cocaine. So let me ask this question. I send you over today and I get those results immediately. Is anything going to show up in your system?
No, Your Honor.
Pardon?
No, Your Honor. Like I say, I got a lot of stuff going on for myself. This is not the only. This is probably the least case that I'm worried about. I'm on GPS tether. I don't have no reason to run or no reason to not show up and come back to court.
That's all fine. I'm more worried about your use at this point.
Oh no, I don't use at all. I'm not trying to pit everything out on the line. If we can speak privately, then I'll be able to tell you exactly what's going on, but I don't want to pit everybody on Front Street. That's it, in the courtroom.
So, did you read over that progress report?
Me?
Yeah, because I'm getting a lot of people that are amoebas.
Yes, I did read over the progress.
They're absorbing cocaine. And I'm not sure how that happens. Young lady appears at Community Corrections, said, I smoked it around him. That must be how he's testing positive. You believe that? You believe, hold on, no. You believe that?
Yes, Your Honor.
Really?
That's the truth.
Counsel Pro, you might want to just be quiet, because the thing I don't like a lot are people that aren't telling me the truth. Because you can go play your game anyplace else. You're not playing it here with me. Counsel approach. Lucinda. Anything else you want to say?
Nothing.
Yeah, I'll give him one shot. You want to tell me? I mean, from what I understand, he comes over from another place. He's in our jail, gets out, and is saying he wasn't using. I got 2 tests. I
understand that, Your Honor. I would just reiterate my request to hold this in abeyance until the lab confirmation comes back one way or another, and to address it at that time. If in fact the lab confirms that it was a positive result, I would ask for that, Your Honor, and I have nothing further to add. But except that Mr. Washington, I do truly believe will be in attendance to its next future court
I'm
date.
not so much worried about his attendance. I'm worried about his using and then lying to me. That's what I'm worried about. And then getting other people wrapped up lying. You're not an amoeba. It's not going to be in your system for 6 days, at least, in this way. Anything else?
Nothing further from me, Your Honor.
I'll grant the adjournment, and maybe, I would have normally, under most circumstances, put it out 2 weeks, but I'll put it out 1 week to the 9th, 2025, 9 a.m. At this point, however, the defendant's bond is revoked. Defendant's remanded.
Thank you, Your Honor.
Court does call the case of People versus Daniel McGu.
Absolutely.
Daniel McGu.
Ready for preliminary examination, or at least to deal with his motions? What are we doing?
Would the court be so kind as to make the self-representation inquiry? And
Yes.
perhaps we could look at the motion first.
Mr. McGu, you are here before the court. You're set today for a preliminary examination. You're here before the court on the charge of resisting and obstructing a police officer. That's a felony, punishable by up to 2 years incarceration, $2,000 fine plus court costs. You appear here unrepresented as you have in the past, and the court has given you the admonishment regarding self-representation. Court is clear, does believe that you do indeed understand the charges as well as the maximum penalties. There are certain dangers in representing yourself, and it can be fraught with some difficulty. However, I would indicate to you that you are absolutely constitutionally entitled to represent yourself if you so choose to do so. I will treat you no better, no worse than a licensed practicing attorney, but that also means that I will not show any favoritism. You are to also understand and know and operate by the Michigan Rules of Evidence and Michigan Rules of Criminal Procedure. If at any time during the course of these proceedings you decide that you wish to be represented by counsel, cannot afford to hire counsel, then the attorney will be provided to you. So that we don't get into a thing, I am going to assume, unless you say something different, that you understood everything that I just said. Hearing nothing different, what are we doing? Sir, do you wish to be represented by counsel? I guess I'll ask that.
I do not.
All right.
Thank you.
What are we doing?
I think defendant has a pending motion.
Yes, go ahead with your motion, sir.
Still waiting, motion to compel the officers. I thought I'd be here today to speak with them on the record. It's what I've been requesting since my arraignment.
I know, but you requested a deposition. That wasn't going to happen. So what is it you're looking for the court to do?
Your Honor, I'd like to speak with the officers on the record. I've been requesting this since I'd like to.
So do you want to have your preliminary examination? Is that what you want to have?
Yes, yeah,
All right.
sorry.
Their response from the people regarding that.
Your Honor, that is one part of the motion.
I know.
And so as to that part, people will be requesting an adjournment of the preliminary examination today as the officers are not here. But as to the other pieces of this, that there are many more things. I did file a written response, which I'm happy to rely on, unless the court has specific inquiries placed to make of that is not sufficiently flushed out.
All right. Sir, what about the other part to your motion?
Is that in regards to waiving my bond conditions? Which part are you referencing, sir?
It's your motion. You go ahead. I will rule on that part. What other part of your motion do you want the court to deal with?
To waive all bond conditions, leaving the state. And I'd like to get the officers on record. That's really what I've been wanting to do. I thought that's what I was here today. I was prepared to do, Your Honor.
Do you have all of the discovery?
I was just submitted an audio file this morning, Your Honor, from the prosecutor. However, it must be corrupt or something. It's not going through. I'm trying to get a valid copy from her. But other than that, I believe I do.
That's correct, Your Honor. We did send over an audio file this morning, and I did see the defendant replied that he was having trouble playing it on both his laptop and on his, I will note it, I'm just seeing today, it looks like the defendant may have a MacBook, and I know that those can have a little bit more of a difficult time with some of the audio files that come from my office, so that may be something that, I don't know that the file is corrupt. I think there's just an issue playing the audio.
Got it. And this is a audio of.
I believe it's the 911 call that brought the officers to the scene,
Got
but it would not be an exhibit that people plan on playing at the preliminary examination.
All right.
I would like then to motion for a preliminary examination to get the officers here on the record then, Your Honor, please.
All right. Is there anything else you needed the court to deal with? You mentioned bond conditions. You say you have all of the discovery. There may be an issue with the playing of this one audio. Is that correct?
That's correct.
Anything else you're requesting?
No, Your Honor.
All right.
At this time.
With reference to the bond conditions, all of the bond conditions are standard bond conditions issued in every case. And so the defendant's motion to change his bond or the conditions of his bond is denied. The court does deem them appropriate and properly set by the magistrate. Does not see an abuse of discretion regarding that. With reference to the court doesn't have to deal with any of the discoveries. We have it with reference to the preliminary examination. I'm more than happy to give a preliminary examination date. I will grant the people's request to adjourn in this matter and would set it for the 21st, if that will work with everyone's schedule.
January 21st?
Yes.
That's fine for the people.
Fine for the, Your Honor.
Yes. So preliminary examination will be set January 21st, 2025, 9 a.m. before me. That's in person.
The courtroom took a serious turn when Levante Washington appeared before the judge after community corrections reported 2 positive cocaine tests. Washington's attorney immediately asked the court to hold the matter in abeyance until laboratory confirmation could determine whether the results were accurate. Washington denied using cocaine and claimed he had no reason to run or miss court, pointing out that he was already on a GPS tether. But the judge's concern was not simply whether Washington would return to court. The real issue was whether he was being truthful. The judge pointed to 2 positive tests taken just days apart and questioned Washington directly about whether anything would appear in his system if he were tested again that day. Washington continued to deny drug use and offered an explanation that another person had admitted smoking cocaine around him, suggesting that this could have caused the positive results. The judge clearly found that explanation difficult to accept. At one point, the judge warned Washington that honesty was critical and accused him of trying to play games in the courtroom. The defense continued to request that the court wait for laboratory confirmation before taking further action. The attorney also emphasized that Washington had voluntarily sent 1 sample for testing and planned to submit another sample after court. The judge ultimately granted a short adjournment, setting the next hearing for 1 week later instead of the usual 2. However, the decision came with a major consequence. Washington's bond was revoked, and he was remanded into custody. The judge made it clear that the central concern was not merely Washington's attendance, but the possibility that he was using cocaine and then misleading the court about it. What do you think about the judge's decision? Was revoking Washington's bond justified, or should the court have waited for the lab results? Like this video, subscribe to the channel, and comment your